Former U.S. Attorney General John Ashcroft. Mr. Attorney General, thanks very much for joining us this morning.
Glad to be with you.
How do you think this plays out? I mean, clearly, Tim Cook wants his customers to know your data is safe. We're not going to kowtow to the government because the government is telling us that I'm supposed to give them a back door, because once I give them a back door, everybody has the back door. How do you see it?
Well, information has been essential to the liberty of the United States, and I mean that in terms of national security. From George Washington forward, we've had to have information in order to protect the liberties of the American people. It's been supervised by the courts. We've had a system of getting information when necessary for national security. I believe there will be a way, and as a matter of fact, all telecommunications companies have cooperated, I believe including Apple, to help provide information in specific cases with court supervision. And I think ultimately we're going to have that. We cannot have an American company that provides a sanctuary or a secure area where terrorists can communicate and can plan and carry out plans to disrupt America and to destroy our freedom. We simply have to have information when it's necessary, both to prosecute and to prevent crimes. And for prevention, information is essential. I certainly hope that there will be a way that the information can be provided without unduly putting into jeopardy the private communications of law-abiding citizens.
Yeah.
However, when there are terrorists working, I don't think we want to find a way to protect their communications. They have to be susceptible to law enforcement understanding.
Yeah, you make a lot of really good points. And I know that this has been done before. I mean, back in the 90s with the telecom companies, when you were Attorney General, I want to ask you about this because we had on Joe Nacho earlier in the program, Mr. Attorney General, and he referred to you back in the day because basically what he says is the government came to him when he was the CEO of Quest and said, look, we have to put pipes underneath the ground. We need to listen in on your customer calls. He wouldn't do it. He says the government retaliated and you sent him to jail. Listen to this. In terms of your case, you weren't sent to jail for that reason. So you think it was a retaliation later?
Well, Maria, that's what your later guest, John Ashcroft, would argue. But Ashcroft was the Attorney General at the time, and the Director of the FBI was an Assistant Attorney General at the time, and they knew that our intelligence agencies were involved in illegal activities.
Was that illegal activities at the time, like he says?
He was convicted of a crime. He was denied any relief on appeal because he was guilty. He remains guilty of that. I think those convictions are still his.
Those were insider trading. Those were insider trading charges, yeah.
So, correct. And why he wants to try and allege now that somehow there was another basis for his prosecution is absurd.
Okay.
The national security part of the Justice Department doesn't work with the criminal justice part of the department in order to do things like that to people. At least it didn't in my administration.
What he was suggesting was that it was illegal at the time for the government to put pipes below the ground to listen in on people's conversations. Very similar to what we're talking about here today, right? Because the government wants Apple to hack into this phone, and Apple is saying, look, if we have a back door for this one particular case, then there's a back door. Then the bad guys are going to get a hold of Apple data, our user data, and they're going to be snooping, and they're going to find out everybody's private information. What do you think about that?
Well, I don't think that's proper. I don't think it's correct. This particular case is a case that is a result of a court order, that we have the judicial system involved, that the government is operating under the supervision or under the authority of a federal judge, and there is an appeal being taken to it. The idea that somehow that the government can never get information to defend the national security because someone might sometime abuse information is absurd. Everything is susceptible to abuse. There are problems with police abuse, but that doesn't mean we abandon the idea of police. Never in our history have we decided that there were commercial interests or privacy interests that were so important that we could not detect illegal activity like the activity of terrorists and use that information about them to protect the American people. That's what's at stake here.
Yeah, I think this is a really, really great analysis, but isn't it a slippery slope? That's the thing, Mr. Ashcroft. I mean, do we get into a situation where, okay, we will, you know, kowtow and make sure Apple hacks into this phone, we get all the information about what this terrorist was communicating with his buddies, whether it's in Syria or in America, more importantly, and we find out lots of information that we need, but is it a slippery slope that then the government says, you know what, there's another case that I need to look at this phone, and then I need to look at that data? What about the slippery slope argument?
Well, the slippery slope, as long as it's appropriately safeguarded, is not a slippery slope. It's a governmental process. So yes, there probably will be times in the future when we will need to have information to protect this country. And it should be information that is gained in a lawful way through the either the Foreign Intelligence Surveillance Act courts or under the authority of the President in Article 2 for obtaining information as his foreign affairs responsibilities or commander-in-chief responsibilities require, or the Article 3 provisions that relate to criminal laws and the ability to have wiretaps, which we have found important and necessary in order to protect the freedom, security, and safety of the American people historically.
Yeah.
The safeguards we've developed before should be the ones we use again, and we should do this. And I think there'll be a way to get this done here. We can't have secure communications for terrorists.
Yeah. I mean, you would think so. And also, you know, do we want the terrorists to think that that's the go-to phone to communicate with their colleague terrorists because they know that it's never going to be, you know, unleashed to government? So what you're saying is there is a provision when it comes to national security, period.
Yeah. Well, you know, there are lots of things that we have that are superior in the United States that terrorists would like to have.
Right.
And there are certain aspects of American government that forbid the sale of high-tech and other very important things that are essential to our defense that would be dangerous in the hands of terrorists. And we've regulated that kind of commercial activity historically. We've done so to protect the interests of our national security, but also to protect the commercial interests of this country. And I believe that we'll find a way to do it in this circumstance that does not unduly compromise individuals. The idea that something might someday be abused doesn't mean that it can't be an important component of our defense system for national security purposes. Yeah. That's true about weapons, and it's true about communications.
I think you make great points, and it's all very much practical analysis.